Well, thank you for joining us for our practice management and compliance with the new legal profession uniform law that came into effect on the 1st of July for West Australian clients. We thought we'd take you through a couple of things that need to be looked at under the new legislation, and with the hindsight that we have after living with the new law for some time now, we thought we'd bring you up to speed. Now, this is quite a lengthy discussion on this. There's about 38 slides here. The slides will be available to you after the seminar here. You will be able to click through and get the slides. Once you've got the slides, embedded within each slide are links to the various discussion points that we have for each slide. So let's get into it. If we have a look at the legal profession uniform law, it's supposed to harmonise regulations of New South Wales, Victoria, now West Australia. Look, we believe South Australia will come on board. Queensland have a similar piece of legislation. It's pretty much exactly the same, just a different name. All of these rules and acts are bound together. So you've got things like the Uniform General Rules, admission rules, professional conduct rules. The one that changes, that we've found changes quite a lot, is the general rules. The rules can be changed by the Legal Services Commissioner pretty much at will. So if there's something that needs to be changed or tweaked, they do it through the general rules. And the general rules are also contain the most prescriptive requirements for a law practice. Look, let's move on to the next slide. The big thing about this act is that it's more consumer orientated. That is to say that it crystallises a lot of the requirements for a law practice for their clients. It's a consumer act, basically. So look, just be aware that it's coming from a consumer's point of view. And one of the big things is about the client engagement and cost disclosure. You've got to have an ongoing recognition of what sort of costs are involved, and you have to keep your client informed. But basically, the one that's been the big sticking point in New South Wales and Victoria is that you must provide an estimated cost to your client. So it's a sort of ongoing thing that you have to do. You have to keep track of the estimated fee. You also have to keep track of ongoing costs, and it has to be put into your, eyesight. You've got to keep that in your eyesight all the time. We'll have a look at the next slide. The cost disclosure thresholds. Now, once you've determined what the estimated cost is going to be of the particular matter, if they're $750 or lower, you don't require a cost disclosure or written disclosure. It doesn't mean to say you don't inform your client of how much you think the matter will cost, but there's no requirement to give your client a written disclosure. 750 to 3,000, a written disclosure is required as soon as practical and before commencing legal work. I think it's important to highlight the fact before commencing legal work. You must inform your client of the costs. Now, these costs are exclusive of GST, so you don't include the GST component. Anything over 3,000, full written disclosure is required. So they're the threshold: 750 to 3,000 and over 3,000. You can use a cost disclosure form. Look, there's plenty of them kicking around. You can use the one from New South Wales, or you could use the one from Victoria. Just have a look at their websites. They do have standard ones, but I'm pretty sure you would, most firms would have a cost disclosure form already in place. Just be aware of those thresholds. Let's have a look at the next slide. Consent. So again, one of the sticking points. We've prepared a fee estimate. Is that sufficient? No, it's not sufficient to send a disclosure form or cost agreement. You have to have some form of active response from your client to indicate that the client has consented to you doing the work. Let me tell you that any work done prior to that consent being given is non-chargeable. You cannot charge the client. So how do you get fee consent? Look, we've put in place with Cabinet a quick way of doing it. Once we indicate to you that a matter does not have a client consent recorded, you would just click on an email. It would send the email to the client. And the important thing is that it has a button on it that says, I acknowledge and understand the matter cost disclosure statements. So in other words, you're actively getting them to push that button and record the fact that they have understood and acknowledged your cost disclosure. So as making it just a simple process is a great thing. But look, let me tell you, if you don't get that client consent or have a period or a date that the client consented, you cannot charge your client. Let's move on to the next slide. Making an estimate of total fees. This was unbelievably confusing to a lot of practitioners. They used to say that, look, it's going to cost you roughly, 200 to 300 or 7,000 to 10,000. You can't give a fee range anymore. It must be an exact figure and it must be recorded. You've also got to take into consideration that it's fair, reasonable and proportionate, having regard for complexity and urgency of the matter. So the things that you would normally do in working out a cost or an estimate, a fee estimate, you still would do, but you have to give a single figure. Another point is the law practice must not act in a way that unnecessarily results in increased legal costs payable by a client. Now, one of the things that has been brought up is if your law practice is using a very old computerized system or a card system or a manual system, and that is causing your fee to increase because of that, then that will be struck down as well. You can't do that. Let's have a look at the next slide. What happens if you don't make the appropriate cost disclosure? It's not a matter of being wrapped on the knuckles. First of all, the important thing is the client does not have to pay legal costs. With the caveat saying until they have been assessed or any cost dispute is finalised through the Legal Services Commissioner. It's quite apparent that if you don't make, the appropriate cost disclosure, the Legal Services Commissioner will strike it down. It's a mandatory obligation on a law practice. You can also be subjected to unsatisfactory professional conduct, and that can lead to civil penalties. And there has been some in New South Wales and Victoria. The other important thing is that a law practice, if they have commenced proceedings against a client for recovery of any fees, they have to cease. They can't go after the client to recover those fees. And also the important point of the law practice bearing the costs of the assessment, not the client. So yeah, failure to make the appropriate cost disclosure, not good. Just make it part of the practice procedures. The very first or second thing after setting the matter up on your computerized system is to make sure that you get a cost agreement and a cost acceptance and a date. So let's move on to the next slide. What are these steps? 1, make an estimate of the total fees. remember to exclude GST. Record the fee estimate in your matter file. If $750 or over, provide a written disclosure, either in full or by a disclosure form. Confirm the client has understood and consented to the proposed conduct of the matter. Get that client confirmation. And track the billing against the fee estimate. Soon as you see that your billings are going near to the fee estimate or above, then that should trigger a couple of things for you. One, you need to recontact your client, identify those increases and get acceptance. Otherwise, they don't have to pay you. So they're the 5 steps. We'll have a look at the next one. Okay, look, this is an ad for Cabenet. Not all law practice software is certified for LPUL compliance. Certified software provides assurance that you use as instructed, practice records and procedures will be compliant. Now, if you're a law practice that's using an older piece of software, it's pretty much guaranteed that it isn't certified. So just be aware that if you are using an older piece of software, you will be pinged or you will be breached because it's not compliant. There has been considerable changes since 2000, and look, we have certain legal practices that we've taken over that have been using manual records and Kalamazoo systems. Look, none of those are compliant, particularly manual systems. They're just a nightmare and they're wasting your time. But make sure that you do have a compliant piece of software. The state that does the compliancing is New South Wales. They do the testing of the software and they issue certificates. Cabenet is certificate number 1. That certification is then accepted by all of the other states. So your Legal Services Commissioner looks to New South Wales to certify the software. And if you have a look at the trust accounting software on the Law Society of New South Wales, you'll get a list of certified software there. So let's have a look at the next slide. Okay, what we were talking about before, the fields that you will need in your software are things like matter creation date. In other words, when did I set this matter up on my system? A field that has a client fee consent date. Now we have the client fee consent date as well as a IP address as well as a physical location, and a field that has a fee estimate. So there's sort of 3 fields that are probably in your systems now, but maybe they need to have a more clearer understanding. Matter creation date, client fee consent date, and a fee estimate. They're already in Cabenet, of course, and the client fee consent date gets updated from that automatic email. So let's look at the next slide. Okay, the way that we would indicate to you that you don't have a fee consent confirmation is in what we call My Matters. If we're looking at a particular matter, you'll see an icon which is highlighting the fact that we do not have a consent from the client, and therefore you would need to click on that icon to generate that email. Now, your system should or must have something along those lines to indicate to you that we don't have a fee consent yet from the client. If your system doesn't have that, please have a look at the latest version of their software. But it's imperative that you get that fee consent. As I said, you can't really work on a matter until you do get that fee consent. So that's the way that Cabenet would handle it, and you should have a look at your software to make sure that you've got that field in place somewhere. Let's have a look at the next slide. I just want to show you what that particular email looks like. It's the disclosure of costs. It's just a disclosure of costs and requests for acceptance. So it's a standard email, just pretty much goes out. We've added a few bits and pieces to it. Law practices would look at it, make sure it's okay, and then click on the email for that to be emailed to the client. So look, if you want more details on that, please get back to us. We can show you that particular email. We'll have a look at the next slide. What we were talking about is making sure that you keep the fee estimate and the work to date in your I line all the time. We call it the matter status. So for example, we've got here a particular matter. We have an estimated fee, which was that field that we were looking at before, and it's gone away and calculated the work to date. So as you can see that you've got a figure there and a work to date figure. Then we come down and calculate how many units that you've got left, the units that we've used, and how many we've got left. We also indicate the dollar value not invoiced, so that you can come up with an exposure figure and a debtor balance. So all of that is in your I line. One thing that we do, if the estimated fee is below the work to date, that whole box will change colour to indicate a matter that is over its estimated fee. Let's have a look at the next slide. Billing and invoicing under the LPUL. Now, this is always difficult for law practices to understand, but basically an invoice is not a bill. An invoice is a creature recognised by the Australian Taxation Office. So the Act does not actually define an invoice, it talks about bills. Now it's assumed that a bill is an invoice, but we have come up with some issues that you really need to watch out for what the Australian Taxation Office says, and it will always trump the billing requirements of the LPUL. So you've got to have a way of recording and tracking the work done so that if asked to justify an invoice, you've got those time entries against that matter. Again, we talked about you've got to be able to monitor the dollars billed versus what's been invoiced. And if the initial fee estimate is exceeded, provide update disclosure for your new estimate. We'll continue on with the next slide. So basically an invoice is made up of billing items in the Cabinet system. And that means that you record what you've done on a matter, whether it's a fixed fee matter or not. You've still got to record your time, what you did on the matter. You've also got to capture any disbursements that you may have had on that matter. But look, we understand that you may be more familiar with using Outlook as a way of recording your time. So what we've done is we've incorporated the ability for you to go out to your calendar on a daily basis and pull those time entries into Cabinet as billing items, which will go to make up your invoice. And we've got other ways of doing it. We've got online timesheets if you're used to using timesheets. If you're used to using time clocks, we've got a recording function for you. And most importantly, things like emails should be able to be shown in a matter so that a chronological list of everything that you're doing for the client, emails, documents, legal work, disbursements and so on are shown against the matter. So with Cabinet, we do have that integration into all of the Microsoft products, Outlook, OneDrive, SharePoint, also task management and so on. Let's have a look at the next slide. So coming back to that invoicing issue, you've got to, sort of run that line with the Australian taxation legislation and also the Act. One of the big things we saw on a lot of invoices was, for example, I come up with an invoice and the total is $5,000. Then it would have a line underneath that says, we are holding $5,000 in trust for you. Therefore, the invoice is zero. No, you can't do that. That's not right. Your invoice must show that it's for $5,000. You can put a statement on your invoice that says something along the lines that we are holding $5,000 in the trust account for you. If you do not dispute this bill within 7 days, then we will transfer that monies from trust to satisfy this bill or this invoice. So you must do that. You can't show a net invoice of zero. That's just not on. Of course, you've got the requirements of an invoice, ABN number, GST inclusive, GST not inclusive. All of those requirements are still there and must be on that invoice. But look, it's my opinion that the tax regulations will always trump the Legal Profession Act. So make sure that your invoices are compliant. And we do have a link to that. We'll have a look at the next slide. The types of invoices that you can issue are what we call a lump sum. And a lump sum is basically where you're saying to your client, I'm going to charge you $5,000. End of story, nothing more. Give me $5,000 or you owe me $5,000. That's a lump sum. Now that's fine, and you can issue that if you wish. Or you can have what we call an itemised bill. And an itemised bill will go through and show all of the work that you've done for that client in a fee schedule. You can also have an itemised but say invoice. So what that is telling us is that I've done this work, but I'm only going to charge you X amount. We would prefer that you use that sort of an invoicing regime rather than trying to show discounts and so on. But look, again, you have the ability to show discounts if you wish. But the two types basically is a lump sum with no itemisation and an itemised bill. Now, the right of the client is that he can request an itemised bill. So if you're not recording your time and what you're doing on a job, then you're going to be in trouble because the client has the right to ask you for an itemised bill. Just be aware that if you think that you can get away with the fact by saying, look, I charged them $5,000 and if I do issue you with an itemised bill and it comes to $5,500, it's my opinion that the $500 is gone. You're never going to get that $500. But look, if it's, you know, if it's worth that much, then you can go to the Office of the Legal Service Commissioner and request that the additional $500 be allowed. I haven't seen it yet, but you know, it could occur. Remember, the Act is a Consumer Act. It's not a Solicitor Act. It's for the consumer. Okay, let's have a look at the next slide. So one of the points, or one of the sticking points that we found is, and you know, clarification of this is required. Do I need to sign the invoice when I send it out to the client? Look, under the Act, of course, an invoice doesn't have to be signed from the Australian Taxation Office point of view, but what it's saying in your Act is that if you issue an invoice without a signature, then all of the principals of the practice will be responsible for that invoice. So if you then send out an invoice that is signed by a principal, then that principal is responsible for the bill. And look, there's another option there. Nominate a principal of law practice as the responsible principal for the bill. You can say that the principal that is responsible for this bill, you can put that on your invoice. Does it need to be a physical signature? No, it doesn't. It's the option of saying who is responsible for the invoice. That's the issue. It's not a physical signature. You don't have to have a physical signature. You don't have to have your solicitor sign every particular invoice, but you do have to make it quite clear if you don't have a responsible principal, then all the principals are responsible for that invoice or bill. It's often the case that the notification of the client's rights are required by section 192 and 272. If you send out an invoice, you must include the client rights. And we do have a list of New South Wales, Victoria and West Australian rights. They need to be on the invoice, and to some degree they actually take up more space on the invoice than the actual invoice billing details. So look, just be aware that you've got to have those client rights attached to the invoice. Let's move on now to the next slide. Okay, what are the issues with your trust accounting compliance? Well, look, just to refresh your memory, under the Act, you've got a general trust, you've got control money, you've got power money, you've got invested money, written direction money and transit money. So you have to determine what type of funds you're receiving. Generally, look, all funds coming in for legal work to be done by the practice is general trust. If it's received into general trust, it usually is the case then that the client would say, look, this matter is going to go on for a long time. I'd like to earn some money on it, therefore transfer it to a control money account. But you can take money directly into a control money account. In other words, the client can say, here's $10,000, I want you to put this on deposit. So you can take the check or the EFT for control money and go straight to a control money account. Power money is, look, I'll let you work that out, but monies that you have control over or power of. Invested funds, have you invested monies into BHP shares on trust? And written direction monies that you receive for a specific purpose, and you have a written direction. And transit money is monies that is, coming to you. And look, it mainly relates to checks, but you might receive a check payable to stamp duty and you're holding it in your safe. Just remember that if you do receive funds for work to be done, then that is trust money. If you're receiving funds on an invoice, it does not have to go into trust. It can go straight into your office account. So let's move on to the next slide. What about funds being received, which is non-trust money? I did mention that. Money received by the practice from a third party without understanding its origin. That's a case that sometimes happens. You receive funds into your trust account and you've got no idea who they belong to. Look, you still have to, I would suggest that you will record it into your trust account and identify it into a special account, or a matter number. So yeah, look, I'd just be aware of that and then leave it there until you can find out what the monies were for. Just remember that any monies received for legal services after a bill is given is not trust money, and you can't intermingle it. We'll talk about intermingling of monies shortly, but you can't take that money and put it into the trust account. It's got to go straight to the office account. The other thing that we will talk about, or we might talk about, is the section 42 about being able to take monies out of a trust fund without having an invoice. Be aware that that is a possibility for you. But look, in terms of receiving trust monies, if you're receiving monies for work to be done, it's trust monies. Let's move on to the next one. Next slide. We're talking about intermingling of trust and non-trust funds. yeah, look, all I can tell you here is if you do this on a regular basis, you will get some penalties for you. But what it is again, you must identify trust money as trust money, and those that are non-trust monies have to be identified as non-trust monies. Pay trust money into a non-trust bank account is a no-no. Okay. Also, keeping monies that are in a trust account which are no longer trust monies is a no-no as well. So it's to catch that situation where a law practice might keep monies in a trust account rather than pulling them out and recording them as income in the name of the practice. So I'd be very, don't leave money in your trust account. That's the important thing. The only way that you can do that and keep that up to date is to make sure that you do trust reconciliations and rectify any errors. So we find some monies that are in there that we haven't recorded, or we go through and we see that there's an invoice there that we could take those funds out. Do those reconciliations. Now, there is a requirement on you to do reconciliations within 15 working days. Look, most of our clients do it on the first day of the month. They get it done. It's so simple. They get it done. And look, it's a requirement and they fulfill that requirement within 1 day. So don't intermingle your trust monies. The next slide, I think, is the interesting one, trust receipting. Do we now have to issue receipts? No, you do not have to issue receipts to your clients on the receiving of monies. It's on request. So there was a subtle change in the legislation in New South Wales and Victoria, which has flowed through to West Australia. So once you've received funds, there is no requirement on you to provide a receipt. But if the client does request one, you do have an obligation to provide that receipt to them. Again, in Cabinet, it's a matter of going to the matter ledger, clicking on the receipt, and having the ability to email that directly to the client. So just be aware that you no longer have to print receipts. The other thing that has popped up is loans to the client. And this is in a lot, what happens a lot in criminal matters, in as much as that the matter is for the son, and then the mother of the son gives money to the law practice, and she stipulates that it is a loan to my son. You would have to create two matters there. One is the matter of the son. The second is the loan to the son. You would have to record the monies in the loan account and then transfer them to the son's account to pay for fees and so on, or you could take it directly out of the loan account. But the idea there is that you would need to have written authority to do that. And then come the end of the day, if there are any funds left over, they need to be returned back to the mother. We have the situation where a large amount of monies was transferred back to one of the partners in a family dispute because the person that was generating the check saw the two names on the matter, but that was not the case. So just be aware that if you do receive funds as a loan, they have to be recorded as separate matters. Let's move on. Control money accounts. Every solicitor I talk to says, "Oh no, I don't have control monies. Don't want to. Never do want to. Never want to see them." Look, your clients are becoming more sophisticated. They're starting to understand that they have a right to have control money account. You have no right to say to them, "I don't accept control monies." You have to accept control monies. Control monies require written direction from the client to post those money to an interest-bearing account. As we said before, money can go directly to your control money account. You need to record the interest that is given to that account regularly. So you should be getting regular statements from your bank in regard to that investment. And look, there needs to be a control money statement given to your client on termination of the matter or on an annual basis. So control monies, look, under Cabinet, easy to run, not a big issue. We have special tools that you can use to record your interest and withholding tax. We have, for example, one client in Victoria who has something in the order of 4,000 control money accounts, and they handle it with ease. So you do have to accept control money accounts, but look, don't be in that position where you think it's horrible. It's not. It's quite easy. Okay, let's go into the next slide. How do you, withdraw? Look, you're pretty familiar with it. You should be able to withdraw funds in terms of issuing an invoice, waiting for 7 days. If there's no dispute, of course, I can then transfer funds. I just wanted to again point out to you the general rule 42.4. There may be circumstances where law practice may need to withdraw trust monies otherwise than after issuing a bill or an invoice. So you do have the right to use 42.4. Where that can occur is, for example, you'd need to lodge a document or you need to generate a search or some other request. You can, under 42.4, pull that monies out, but you need to advise your client of that withdrawal in regard to 42.4. Now, that can be a telephone call. That could be a statement that says that we are going to withdraw funds for X, Y, Z, but you do need written authority to do that. And you must get that before you do the transfer. So be aware, 2 ways you can get monies out of your trust account. One is issue the invoice. Secondly, invoke 42.4. But the invocation of 42.4 requires written authority. Let's move on to the next one. Credit cards on trust accounts. This is a classic. I love this one. Can a law practice receive funds into a trust account on a credit card? Yes, they can, as long as any fees are taken out from another account. So in other words, the credit card amount must be the whole amount. It needs to be deposited into the trust account in whole. Any fees that may accrue from the credit card transaction needs to be handled by a separate account, an office account. So it's got to be the whole transaction amount is to be credited. And look, there are bank accounts that do that for you. They will set that up for you, and then any funds coming in via a credit card get the fees go to one account, the office account, and the total of the amount goes to the trust account. But let's have a look at the next slide. Be aware of chargebacks. These are fraught with danger. Now, what is a chargeback? If you're not sure, it's the situation where if I've, for example, purchased something on a credit card, I can contact my bank and say I'm not satisfied with the goods and I want a chargeback. I can lodge a form, and it can take up to 90 days. But if a credit card is used for a trust account, your client has up to 90 days to request a chargeback. So look, it's pretty horrendous if you're going to have quite a considerable amount of money entered into your trust account on a credit card, and then a chargeback occurs, and that chargeback occurs, you have no pretty much no notification of it. It'll just happen. If it's something that the law practice is prepared to live with, that's fine. Maybe, smaller amounts on credit card, or you set a limit for the amount of credit cards that can be processed, but be aware of chargebacks on trust deposits. Just point two, if the practice is drawn against the funds and the chargeback goes through, you'll have to put those funds back in to the trust account from the law practice. Okay, let's move on to the next one. Just another couple of things now. Statutory deposit accounts have to be calculated quarterly. In other words, you have to figure out what your statutory deposit should be at the end of each quarter. We have a little calculation table based on your cash book. The Act says it should be based on the bank statement, but look, if you're processing regularly and you're keeping things up to date, it's quite okay to get an idea of what your statutory deposit should be. In most cases, it might say there's no change to the statutory deposit that's required. The calculation's pretty straightforward. It's there. There's two periods. There's the actual quarter that you're looking at, and then there's an extended period, 15 days after the close of the quarter. It's the lower of the two amounts that is required in your statutory deposit. So look, we've got that covered for you as well. Let's move on to the next slide. Look, I'm going to refer you to managed investment schemes. If you're a law practice that does have managed investment schemes, you probably know more about it than I do. So look, I would suggest that you click on that legal profession general uniform rules and have a look at section 258. Let's move on to the next one. The registers are a big thing. The external examiners and investigators are always on the lookout for this because they thought that law practices were deficient in this area. Basically, the registers that you are required to keep, of course, it's the safe custody register. Your safe custody register under Cabinet is a place that you can store things like wills and powers of attorneys and so on. In the past, law practices have had packets where they could have a will and they could throw the will into the packet and then they record it on a piece of paper or in a spreadsheet. Look, every document that you receive under the Act is now a regulated asset. That means that it has to have its own unique number, its own unique place. We do that for you. We record that. You would still need a safe, of course, to put the document into the safe custody. But look, Cabinet's got you covered there as well. Being a regulated asset, what that means is that it's available for external examiners to look at or for investigators. It is part of the records of the law practice. You also need a financial interest register, so you need to keep track of any financial interest that the law practice may have. And you need a register of powers and estates. Look, if you need more assistance on those, get back to us. We can fill you in. But look, we've got you covered as far as those registers are concerned. You just need to record them. Let's move on to the next one. This is an overview of the compliance areas with all of the various links involved, and we've got another screen for you with more links on it. So look, please download the slides so that you can click on those links and follow them through. We might move on. And this one here is a fact sheet which provides all of the information with links to the various places that you would be looking at. So look, that's about it, I think. Let's have a look at the last slide. Yep, that's it. Great. Sorry that it was so long, but Cabinet has been around since 2001. We've been keeping law practices compliant for some time. We have you covered for your trust account your office account, your control money account. We've got you covered for your debtors. We've got you covered for your invoicing, compliancing issues, your matter registers and so on. As I said, we're certificate number 1. We've gone through the mill quite some time, for some time. Just to give you an idea, if you're looking at just a practice with 3 people who just want to use all of the accounting functions, it would be $75 a month. If you're a larger firm and you want up to 9 users, it can be $180 a month for the 9 users. If you wanted our live integration into things like Outlook, Word and so on, for 9 users, for example, you'd be looking at $360 per month. The point is that we don't want to make you go bankrupt by using the tools to keep you compliant. You've got to keep compliant, so we're trying to make it, our brief is to keep you compliant at the lowest possible costs. So thanks very much for that. Thanks for your attendance, and look, don't forget to click on the link to download the slides. Thanks a lot.